There's been a conversation in the publishing world recently about whether or not we can be using an AI that allows us to create audiobooks with the voices of deceased celebrities. Let's talk to everybody's favorite IP and entertainment lawyer to find out more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that is dedicated to all things intellectual property.
The publishing industry is having a conversation about AI-generated narration for audiobooks. And somebody brought up an interesting point that companies are starting to consider allowing us to be able to use the voices of people who are no longer with us. They're looking to use the voices of dead people to then audiobook narrate what we are creating. What is the legal side of this, Tony? Because it sounds like this is a very interesting conversation.
It's a very interesting conversation, also very dangerous waters for a number of reasons. But let's kind of break it down. You've seen my videos with Cam before. Obviously, check them all out. We've covered a bevy of different topics in the world of IP. The 6 branches of IP are copyright, trademarks, patents, trade secrets, trade dress, and then personality rights. Personality rights you may have heard of as NIL, name, image, and likeness, especially in the college sports scene if you're a college sports fan. But for the purposes of this discussion, we're going to call it personality rights. Personality rights are the only area of intellectual property law that are not regulated at the federal level. With copyright law, it's regulated with the Copyright Act of 1976. With trademark law, it's regulated with the Lanham Act. Trade dress, which is an offshoot of trademark law, also regulated by way of the Lanham Act. Then you have the America Invents Act and the Patent Act for patent law. And then you have the Uniform Trade Secret Act, which is the federal law on the books for trade secret law. But then we have personality rights, the only exception to the rule where states determine the standard, the rules with personality rights. So personality rights involve the use of one's name, image, and likeness for commercial use. And related to that is then postmortem personality rights, which is when you use a dead person's name, image, and likeness for commercial use. Personality rights have no boundary whatsoever. It applies to living people like you and me, but it could apply to celebrities, or athletes, and so on and so forth. So personality rights covers the spectrum. Everybody has personality rights, and everybody's afforded rights under personality right law when it comes to their name, image, and likeness being used for some type of commercial nature. But for the purposes of this discussion, obviously, we're just going to highlight postmortem personality rights specific to celebrities who are going to be potentially narrating these audiobooks. So postmortem personality rights deal with the use of a dead person's name, image, or likeness for commercial use. The problem with that is that each state, if they're even lucky, has law that lays out what the standard is for how long the term is for postmortem personality rights. So once they die, how many years can that postmortem personality right last until it expires and enter the public domain? And each state varies. So for example, I'm in New York. New York has a 40-year postmortem personality right term. So if someone were to die today in 2023, that person's postmortem personality rights last until 2073. In Florida, it's also 40 years. In California, with the California Celebrities Act, that is a 70-year term. But then meanwhile, in Indiana, it's 100 years after the death of a person. But then in little old New Jersey has no personality right law and memorialized in any writing whatsoever. So they adopt the common law standard 50-year term, which is the standard across the board through other states that do not have postmortem personality right laws on the books. So imagine 40 years for New York, 40 years for Florida, California 70 years, Indiana has 100 years, New Jersey has 50-year common law standard. It's a game of whiplash where you're turning your head left and right and you don't know which term, or there's no consistency rather with any of those terms. So that's the frustrating part with all of this. That said, now that gets to even more, you get into even more complexity with postmortem personality rights, which is that not, a person, a celebrity or an athlete dies, you can't just say, oh, they're a celebrity, therefore California law governs because they're a celebrity. That's not the case. The way postmortem personality rights are applied, you look at where they were domiciled, meaning where were they an active resident, where did they make a prominent presence in that state, in that jurisdiction. If they lived all their life, let's say in New York, but they moved to California, if they were an active resident in the state of California for, let's say, the last 5 years of their life, California postmortem personality right law will govern. If it's the inverse, where they spent all their life in California, but then moved to New York and they were an active resident of the state of New York for 5 years, or let's say even 1 year, still New York law is going to govern because that's where they were domiciled. That's where they were an active resident at the time of their death. So the three factors of postmortem personality rights that you need to look at are: where did they die? Meaning, where were they a resident at the time of their death? Okay. When did they die? Because the year factor is going to affect then factor number 3, which is depending on when they died, what and where they died, what is the state's standard for postmortem personality rights? And that may be based on the active legislation that is on the books in that state or the common law standard. So if Joe Schmo dies in the state of California in 2023, that means that the California Celebrities Act is going to govern, and so his postmortem personality rights will last until 2093. If he died in New Jersey, however, in 2023, it's going to be a 50-year term that would be applied. That means that his postmortem personality rights would expire in 2073. And this actually was fleshed out in great detail in the Hebrew University for Jerusalem case versus Einstein, General Motors case involving Einstein's name, image, and likeness, where HUJ, the executor of the Einstein estate, basically sued General Motors for personality right infringement when they photoshopped in an ad campaign for People magazine and other magazines a photo of Einstein on a guy with like 8-pack ripped abs with an E equals MC squared on his tattoo on his shoulder. Obviously, the estate, which is an extremely conservative entity, was very upset by this, sued for personality right infringement. The argument from General Motors was that Einstein's personality rights expired because he died in the state of New Jersey in 1955, and New Jersey adopted the 50-year common law standard. But meanwhile, the estate was arguing that it should actually be 70 years because the standard for copyright law is the life of the author plus 70 years. They were hoping that the argument for 70 years would actually hold weight in court. Also, the weird thing about this case was that it dealt with Einstein, who was a resident of New Jersey, and somehow this case ended up all the way in California. Weird. But either way, initially the court argued that his personality rights expired because of this 50-year term that exists in New Jersey. Right. And now this led to chaos in the Einstein estate headquarters, but they were able to settle off. They appealed the decision, but then ended up settling off court with General Motors. Part of the settlement was to vacate the decision that ruled that Einstein's personality rights expired. So all that to say, you can see that just from that case, there was a great level of complexity. And I think that is truly the case with something like this, where some AI system is going to have dead people narrating. It only feels like you're entering dangerous territory because of the wild, wild west that is the personality right law landscape.
So we have to make sure that we do actually have the rights to use those if we are going to be working with a company that allows us to do that. Let's say we are in the future going to have access to the voices of people who are dead to narrate our audiobooks. How do we, as people in the publishing industry, double check to make sure we're really safe to use that, aside from just blindly trusting the companies we might choose to work with?
Right. So first things first is to do like a very thorough audit of everything under the sun. If you want Macho Man Randy Savage, the face of WWE for decades. Oh yeah. If you want him narrating your book, you got to make sure that his postmortem personality rights are expired, because at the end of the day, if you start using his voice to narrate your book, you better believe that you're going to get a cease and desist from the estate, arguing that you're using his name, image, and likeness for commercial use. And this is in tandem with an iconic personality right law case dealing with Bette Midler, who obviously, thank God, is still alive. But Bette Midler sued Ford Motor Company for infringement of her personality rights after Ford had approached her about getting consent to use her song "Do You Want to Dance" for an ad campaign for Lincoln Mercury, which Ford was the parent company of. Bette Midler and her agent said no. Ford and their ad agency then went to her backup singer, Ulla Hedwig, said, "Hey, can you recreate Do You Want to Dance?" She said yes. She did it. Ad campaign airs. Bette Midler is livid, sues for personality right infringement under the California Civil Code Section 3344, which explicitly states that if use of one's any unauthorized use of one's name, image, and likeness, including one's voice for commercial use, gives grounds for a personality right infringement claim. And she won on that basis in the Ninth Circuit. And the court affirmed that her voice is as much of a part of her identity as her actual name, image, and likeness. So Randy Savage has a very distinct look to him, but so did his voice. His voice is very distinct to him. So he's dead, unfortunately, but if you start using his voice to narrate books, you're using his name, image, and likeness, his personality rights for commercial use. You're using it to encourage people to buy into the program, the AI program, to have this as availability, as an available option for readers that take in audiobooks. And they're going to see that, the estate's going to see that as a prime opportunity for them to go in and sue for personality right infringement claim. So anybody that is entertaining this type of software really, really, really needs to make sure that they're choosing a celebrity that died in a specific state where their personality rights have been expired. And if that's the case, then you're good to go. So if miraculously you have the voice of, let's say, Thomas Edison, his personality rights have long expired, you could probably go in for that. If you picked, let's say, again, if by some sheer chance there was a miracle out there where you had the voice of Abraham Lincoln, again, probably good to go there. But if you start picking more contemporary artists like Tina Turner, who just passed away, rest in peace, or Randy Savage, or Michael Jackson, or any other celebrity out there that has recently passed away, where their postmortem personality right clock is still ticking, that's when you're going to have a big issue. Now, if you do want to use those celebrities' voices, it's very simple. You just contact the estate, you ask them for permission to license those rights, and you're good to go. But it's a matter of asking rather than just doing for the sake of doing. And of course, if you have any speculation about this whatsoever, please, 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 please contact an intellectual property lawyer who is well-versed on personality right law. This is not some type of nilly-willy kind of thing where somebody's going to say, oh, yeah, this is totally okay. There is such complexity with personality right law as it is that it's going to require a great level of detail and review. So working with a lawyer with something like this, especially if you want to pursue licensing of a deceased person's voice for an audiobook narration, that's where this is going to be a very pivotal part of the conversation.
Now, while we're not at a place in our industries where we are actually able to license dead people's voices to narrate our audiobooks, we're starting to get into the world of AI creating those audiobook narrations. Theorize with me for a moment, Tony. How would this be credited? Let's say we do pick a celebrity that has left us and we have the rights to license that. How would that be credited on our audiobooks? Would we have to say it's AI generated? Would you include their name? Would we just let it go? What would that look like?
So that you get into a lot of weeds there. One is the ethics of this. So, I mean, we're at a place where it's kind of hard for people to really know how do you properly credit something that was AI generated. That gets to more of like a standards and practices, ethical standard that I think varies with each person. So maybe making those necessary legal disclaimers, like this is completely generated using artificial intelligence, is the kind of thing that would have to be referenced. That's the kind of thing I think also would be crafted by a lawyer. So you would need to make that certain disclosure because you don't want to create some type of fraud or deception when you're making a product of this sort. So, or using a product of this sort. So working with a lawyer to create that type of legal notice or credit notice, whatever you want to call it, is imperative. If you end up working with a deceased person's estate, oftentimes they will let you know what the proper credit notice is for the use of that dead person's name, image, and likeness. If they're in the public domain already, I mean, I think it's the kind of thing where you could just say that this AI-generated voice of Abraham Lincoln is, not the actual voice of Abraham Lincoln or something to that effect. Obviously, you can see that even I myself am struggling with it because this is such new terrain, and we really haven't buttoned it up yet, which then gets to the broader question, which is we're so far behind as it is with this mass proliferation of AI that the legal standard of having checks and balances with AI is non-existent. It's actually it's more at the micro level rather than at the macro level with federal legislation. So I think this is more of me imploring if some congressman or woman is out there watching this, this is more of me as a citizen and as somebody who takes great pride in studying and teaching IP. This is me crying out for legislation that will help create some sense of regulation about AI, because at the end of the day, it's great what it can do, but it's also scary what it can do, what it's capable of doing. And it's a matter of just having ethical standards, good, proper legal standards that will help create a refined system moving forward.
Fantastic. And if people have further questions on this, now's a great time to drop those down below. Tony's coming back for more episodes to keep us legally protected inside of the publishing space so that we are not struggling as new technology continues to roll out. We will be bringing you breaking news inside of this space. And if you have further questions, you can always reach out to Tony on his social media. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor, and you can check out my Entertainment Law Podcast, End Scene, and Entertainment Law Podcast. New episodes drop every Friday on Spotify, Apple Podcasts, or wherever you listen to podcasts.
If you have questions, drop those down below and follow along, because Tony is coming back for more episodes to get your legal questions answered in the publishing world. But we're also dropping daily episodes to help you navigate the publishing industry so you can make this your most profitable year ever. We'll see you in the upcoming episodes.